publish in Arabic, as well as European languages, but there are other scholars from Turkey, from the Balkans, from other parts of the Islamic world involved in these issues. I think this would be an aspect of a peaceful coexistence in Europe, since from this point of view Muslims are obliged to obey to the laws. Nevertheless, there is a new trend. There is a new trend, especially among younger generations, saying, no, we are not foreigners here. We are not in a permanent religious state of emergency, which means, okay, we are outside, we cannot demand that we can live according to our system. We are a part of these lands. We are citizens of Europe. We belong to these countries. We want to engage in public debates on legislation, on the future of our countries, etc. So I would call this new approach an entrenchment approach. These Muslims would simply perceive themselves to be part of the societies they are living in, and would say these distinctions between the two camps and then the intermediate category is developed in the past. By the way, you don't find it in the Quran, nor in the Sunnah, in the traditions of the Prophet of Islam. You find it in the books of the scholars of later times, developed in times of opposition between the camps. And they would say this is now a dated concept. Let's try to find new concepts. And just to give you an example, in my country, in Germany, during the last year, 1.5 years, at 4 universities, we have now chairs for Islamic confessional theology. My university is one of these 4. And our colleagues now, our Muslim colleagues, they are teaching confessionally, according to the German constitutional systems, as the Christians or the Jews or others would. They say, let's not always talk about what are we entitled to do, what should we avoid to do. Should we take a job in a restaurant where we have to serve alcohol to the guests, etc., etc. All these ritual questions. They would rather ask, what is our position towards the financial crisis, towards the preservation of the creation, towards aging people and how to make a sustainable life for them, etc. So issues, climate change, etc. Issues which are relevant for society as a whole. And I think this is a really interesting and important step. You would not only find these debates in Germany, but in other countries. But I'm really happy that we have it now on a proper scientific level, on equal footing with the other sciences. So now, what is the European legal framework? I try to be brief about that. Especially, I will be brief today as it comes to the legal norms of Sharia to be applied within certain limits in Europe. And I would more stress on the religious part, since I don't know whether you are informed, there will be a doctoral seminar tomorrow, which I think is open for everyone who is interested, where I agreed to stress more on these concrete legal issues, the conflict of laws in the narrow sense. So I try to give you a glimpse about that, but tomorrow in more details than if you wish so. I already told you the European legal framework concerning religious norms, including those of the Islamic Sharia, enjoys freedom of religion, which is far-reaching in all European countries. We have some common ground within Europe. We have Article 9 of the European Convention on Human Rights, which explicitly declares that freedom of religion and belief, by the way, you have the right to be non-religious, to change religion, to abandon religions. There is a broad common standard reducing religion not only to the private sphere, but also opening broad space in public. But there are some differences. There are some differences in different European states, and the European Court of Human Rights would accept these differences under the judicial technique of granting a so-called margin of appreciation. So, to a certain extent, the member states have the possibility to rely on their particular religious heritage, and that's why, for example, the situation in the UK and in France is so different. in the United Kingdom, it is possible usually for teachers, for state staff, administration staff, Muslim females, for example, to wear a headscarf. This is not a problem there. Whereas in France, it is even prohibited for the pupils, for the scholars in schools, to do so. We do have this idea and this system of communitarism in the UK, which is an old tradition. You can root that back to colonial times. The British ruled the waves in many parts of the world by sticking to a communitarian system which left a lot of decision on the local and regional level on the existing powers, as long as they paid taxes and left the superior regime to the Brits. So no intervention into communal particularities, and that's why Anglo-Mohammedan law could develop in British India at the time, and British judges in British India applied this law, very often wrongly because they were ill-informed about the contents, but nevertheless they thought we'll leave that to them. Whereas in France you have this idea of unité de la République, and so in Western Africa the school pupils were told, nos ancêtres les Gaulois, our ancestors, the Gallians, which was not that much true in Western Africa, I think. But this idea, we have to have this unity, and religion is a danger for politics, though that's why you have these laws from 1901, 1905 in France trying to restrict the Catholic Church, especially at the time, from public space. And to a certain extent, these differences are respected by the European Court of Human Rights, since all international treaties, and the Convention is one of those, is a sort of compromise. You have to, if you want to keep the different members, you have to leave them a certain space of self-decision anymore. But nevertheless, there is one common principle: secularity. Secularity in the sense of openness for religion, but under clear conditions. A clear separation between state institutions and religions and beliefs. So the state sphere is not religious, and religious bodies, religious people do have their space in public space, but not as representatives of the state institutions. Of course, parliamentarians are very often religious people, but they then don't represent a religion in the parliament, but they represent the people. They elected them, the people as a whole, in parliament. So this is the basic idea. But please don't mix that up with a separation between religion and politics, which is demanded by some, maybe some extreme secularists, laicists, which is simply not true. Of course, religion has a say in political debates. Think about all these new debates of new forms of creating human life, of how should we enable people to die if they wish so, if they are ill to death but cannot die, suffering heavily, etc., etc. So in all these debates you have very often religious communities are asked, what is your point of view, what is your stand? And many ordinary people would bring in their religious arguments. I myself, I'm Christian, practicing one, not here in this function, of course, but as a scholar. But of course, from time to time in the political debate, I would try to bring in my arguments from a religious point of view, but we have to, in a way, translate our arguments to a secular debate. So we cannot claim that since we think this is the truth, the others have to accept this truth. Of course, every religious person may claim the only way to the truth. This is up to everyone. But the interesting thing is how to deal with different opinions, and there secularism comes in. We do need an open secular space, a market of opinions, if you wish so, to be able to exchange our positions, religious ones, non-religious ones, atheist ones, and all of them have their equal value in the debate. That's what we have to accept, and that's the true meaning of secularism, which then requires two things: by the state. First, neutrality. The state has to be neutral towards religions and beliefs. And equal treatment of all religions and beliefs. So the majority does not count more than minority religions. And this is, of course, hard to implement in daily practice. Very often the majority would think, well, we are the majority, so why don't we rule? Why don't we implement all our ideas? And there, we will discover a big difference between two principles which are very often taken to be identical, but they are not at all, which is democracy and the rule of law. Very often democracy is understood, the majority, the rule, the decision of the majority counts, full stop. This, by the way, is the perception of democracy by quite a number of Muslim extremists who would say, okay, this is this man-made law, one day this way, the other day another majority, the opposite. But they don't understand the system, because democracy is only one side of the medal. The other side of the medal, and the even more important one, is the rule of the law. So if you look in European constitutions, if you look into European legal systems, you will find out that in case of conflict between democracy, which means the majority, and the rule of law, the latter will prevail. Maybe except in Switzerland for some time. Maybe you recall the polls on the prohibition of building minarets in Switzerland, which have taken place in 2009, and a majority of 57% of the Swiss voters voted for yes, we want to have a constitutional amendment provision prohibiting building minarets in Switzerland. Switzerland was heavily endangered by minarets since there are already 4 in the country, so maybe a 5th would have come in the nearby future. Nevertheless, I'm in close contact with many Swiss colleagues, and all of them would say this will not survive in Strasbourg before the European Court of Human Rights. It's a clear violation of Article 9. Nevertheless, there you see the majority can decide on the rights of minorities. But this is impossible under all the other European constitutions either. So these catalogues of fundamental rights, of human rights as we would call them, are immunized against democratic majorities. So human dignity is inviolable. And even a parliamentarian majority of 100% may not infringe this right. Saying, yeah, a bit violable in case of need for the state, etc. No, clearly not. And the same is true for all the other human rights. So if you look at the ground of daily practice in courts and administrations, you will easily find out that very often these human rights, including freedom of religion, are protective rights for the sake of minorities. And the single individual is the smallest minority in this game. Very often we do have cases, let me take just a few examples, and it's not always Muslims. Take the Jehovah's Witnesses, for example, in custody cases, where family courts have to decide, in case of divorce, on whether the child should stay with the mother or with the father if they cannot agree on common guardianship. We do have cases from several European countries that when a Jehovah's Witness was one of the parents, the decision was made in favor of the other parent, to the detriment of the Jehovah's Witness. And sometimes only because it was said, these are Jehovah's Witnesses, they are strange, they don't care about the children, you know, they are forbidding blood transfusions, etc. in case of need, which some do, but others don't. And the courts had to rectify these decisions at the end and say, now, we have to look at the concrete case. What is the single individual person doing? How do they use or abuse their rights? And then we have to draw the limits if these rights are abused. But everyone, even if the majority is of the opinion these are strange people, they do have the right to be strange. Everyone, I mean, from our professors in universities, there are expectations. We have to be a bit strange, otherwise you will forget us, of course. So strangeness is a kind of fundamental right for everyone. No one has to judge on that as far as you don't breach the limits of the freedoms of others. And if you analyze cases, I analyzed hundreds and hundreds of European cases during the last years regarding the religion of Islam and its legal position under these respective laws. I found out that in many, many cases, maybe more than 90% of the cases, you can really say that courts try to support these adherence to the minority, if you want to talk about minority, majority, to give them protection under the rule of law, which has to be equally implemented. Let's just talk about some particular difficulties. If you say neutrality and equal treatment, you can do it in two ways. You can say formal neutrality, or you can claim more than that, which we call now in a new European research project, which is, by the way, headed by the University of Leuven. My dear colleague Marie-Claire Fauretz from the law department is the leader of the program. I am leading the part on family and the law under the frame of religion and secularism in Europe and how do legal orders cope with religious pluralism. You can say we treat everyone equally in a formal way, which would always, of course, protect the majority much more than the minority. Formal equality, I think it was André Gide who said formally equal would be to prevent the poor and the rich equally from stealing bread and sleeping under bridges. So we need more. We need a kind of inclusive even-handedness, which respects the fact that for the minority, coping with the system is structurally, very often at least, a bit more difficult than for the majority. Take holidays as an example. For everyone in society, but particularly for Christians, it is very easy to practice their belief if they want to attend services, for example, Christmas, Easter, etc. Because these are our legal holidays. They are now secularized, so it's not a privilege of Christians alone to have holidays and the others have to work. No, it's in a way secular holidays for the use of everyone. Day of rest. So the trade unions were very much in support and still are in support of these holidays. But take then Muslims, take Jews, take others who don't fit into the calendar. How to deal with them? We simply cannot await that new holidays will be introduced in a broad way. Many people would like, perhaps. So we would have 20, 25 instead of 10 or 12 or 13, but it's not very realistic at the time. But then a legal order and administrations have to thoroughly examine the case and find solutions within the system, which would mean, for example, that Muslims or others are entitled to apply for not attending schools, for example, at these holidays, either Adha, Eid al-Fitr or whatsoever, or to get a day off or 2 days off, take holidays or whatsoever. And usually these solutions can be found, but they have to be found as well. And I think it's good for the majority always to remind that life, such life, religious life included, is a little bit more difficult for the minority than for the majority. Let me just take one example, which is debated actually in several European countries, where we can try to detect the kind of arguing and the scope and limits of religious freedom, namely the burqa issue, which was an issue and still is in Belgium and in other countries, I know. Of course, it's not about the burqa. Mainly, I never saw a woman wearing a burqa here in Europe, never. I've been in Afghanistan twice, I saw a lot of them. So this is this typical Afghan way of covering the head, this garment, which just leaves kind of gitra in front of their eyes. The thing, the garment, which is usually called the burqa, is niqab, so-called niqab. It's a Saudi Wahhabi tradition of a garment leaving open, usually the eyes, but nothing else. It's in progress in many parts of the world. coming from Cairo, I can tell you, 30 years ago, which was my first time in Cairo, I never saw a niqab, only in Upper Egypt, in some remote areas around Aswan maybe, but in the rest of the country, no. Now, even in Cairo, even in the center of town, you see this niqab progressing. There's a strong Saudi cultural influence. I